Okay, guys. So I'm Dave Schwartz, and actually my co-author and former colleague Chris Buckafusco is right there. I'm going to talk about a project we've actually been working on for a while that we call Studying Uncertainty in Intellectual Property Valuation. And so we have really two main goals. I'm going to talk about the second one today. The first is just to create an experimental measure that we can use to investigate how features of IP disputes affect judgments of IP values. So there's some really good ways that people experimentally have done this, and we think ours is kind of artful and useful. And then we're going to use that measure to study a particular issue with respect to uncertain IP valuation. So I want to first talk about the theory on this uncertainty in IP valuation. And what we're talking about is temporal uncertainty. And so by that we mean that the value of an IP right, and it doesn't have to be patents, our experiment deals with patents, but it applies equally to copyrights, can be different ex ante as it is ex post. Okay, and so ex post we know if the product was commercialized whether it's successful or not. But ex ante it's kind of uncertain whether that product's going to be successful, and so we might look at the distribution of likely outcomes to figure out what that probability is and what the value is. And so if we wanted to use a real property example, or not real property, but at least non-intangible property, we could think of lottery tickets. Okay, and so let's say that we have a lottery, let's say there's 100 lottery tickets, they each cost $1, and they give you a 1 in 100 chance of winning $100. So they're like a completely even bet. And so ex ante, the value of that ticket before the drawing is $1. And then let's say that after the lottery, your ticket is either worth 0 because it was a loser, or it's worth $100. And so that was what we would call the ex ante and ex post values. I think this works well using Mark's kind of probabilistic patents idea that we can think of IP rights in a similar vein. And so the question that we're looking at is kind of what's the best measure of IP value, this ex ante or ex post? Now, under theory, either one of them could be efficient. And so if we gave everybody the ex ante value, and we had, let's say a lottery ticket was, one person got it, it was really the other person's, and so we need to compensate the person that lost it. If we gave every one of those people that lost it $1 back, then we did that 100 times, there would be $100 a change hands, that's the right amount of money. If we did it with the ex post value, we gave 99 of those people $0 and $100. Same result, efficient distribution of money. But Omri Ben Shahar from Chicago has argued in a paper that the patent and trademark laws are inefficient because they allow the rights holder to elect to get either the greater of either of those remedies. And so he kind of loosely calls reasonable royalties the ex ante measure, like what you would have negotiated beforehand, and either lost profits or disgorgement of profits, that's the ex post measure. Tom Cotter has a critique of this that I find somewhat persuasive, but this is in the literature, and we're thinking about this kind of theory that's out there. And so we use this to kind of frame what we're looking at. And so what we want to know is, how do people respond to questions of this kind of temporal uncertainty? We're going to look at it in IP law, although it actually comes up in a lot of areas of law. You can think of the real property example where, from 1L property class, where somebody paints the wrong house, and it actually makes it more valuable than it would have been otherwise. What's the proper compensation in that? And so what we want to do is look at, more particularly, these two hypotheses. The first one is the Omri Ben Shahar hypothesis that just people's intuition is going to be to give the greater of measure of damages, either whatever's higher, the ex post or the ex ante measure. And then the other one is, kind of a classic theory of hindsight, which is you always, once I tell somebody what the results were ex post, they're always going to give the ex post number. And so we're not sure if that's really how it works, and so we wanted to investigate this. And so what we decided to do was to use some experimental approach. We used Mechanical Turk. We're happy to chat about kind of the well-known limitations of using Mechanical Turk, and we use Qualtrics kind of on top of Mechanical Turk to help us administer the survey. We used a series of vignettes. I'm going to show you those vignettes in a minute so you can take a look at them. And then subjects were kind of randomly assigned two similar vignettes. So the only differences we should see are because of, either you get the treatment or you get the control. The treatment and control are going to be the boom and the bust. And then we used a between subjects design, so everybody got either the ex ante or the boom or the bust condition. You don't get both of them. And then just to give you a little sense of what we did, is that we did actually kind of, not just run this on a mechanical turf, but the kind of best practice is to go out and run this and kind of observe a whole bunch of lay people taking this experiment, ask them, why they're doing things, look at where they're clicking, and so we did that and kind of got detailed personal feedback, and then we ran it on a bigger ad, right? We ran it on like 600 people. And so here's the basic vignette. Paul invented a new car battery in 2010. He received a patent from the government that covers the invention and prevents other people from making the same invention. A month later, Fred, another inventor, independently invented his own car battery. By chance, Fred's battery was very similar to Paul's. Fred infringed Paul's patent when he started making and selling his battery in 2010. Paul discovered Fred's battery a couple of years later after Fred began making and selling it. Paul sued Fred, and the two inventors spent several months trying to settle their differences. Eventually, Paul and Fred came to an agreement that Fred broke the law. They couldn't agree on how much money Fred should pay Paul for having violated the patent. After Fred and Paul realized they wouldn't be able to settle, a trial took place approximately 4 years later. And then we've got two different conditions, and I've highlighted just for exemplary purposes what's different, which is in bold, but it wasn't bold in the version they saw, is that there's some testimony that the ex ante value was a very large chance that it was worth $1, so likely to be unsuccessful, and a small chance that it was going to be successful, $15. And therefore, the expert determined that the value of the patent at the time Fred violated the patent was $5. And then we give him the kind of boom condition. It was very successful, and therefore the expert said that at the time of trial, it was actually worth $15. And we have a very similar one for the bust condition, except we just tell them that it was actually unsuccessful and that it was worth $1 a unit. And then we have this kind of call of the question to them, where we just say in the boom condition, patentee asked for 15, and the accused infringer asked for 5. And then we don't really tell them what the law is. We just say, what do you think the appropriate amount that Fred should have to pay Paul? And then we have, very similar, though with different values for the bust. The patent owner asks for the ex ante, and the accused infringer, and the infringer asks for the $1. And so we ran this. Let me show you what the histograms are of the results. So we've got on the left is the bust condition. And so remember that the ex ante value, the kind of like likely probability beforehand, is $5, and the ex post value, because it's unsuccessful, is $1. And so we have is the ex post value is the modal observation, right? Almost 40% of people did that. And then we get these people that kind of split the difference, right? That either give $2 or $3. And then actually like a smaller, like 20% of the people give the ex ante value. And then we run it and then in the boom conditions, so same subject population, just a random sample got the boom condition. We see the modal observation is the ex ante value, right? Almost 40%, with a small number of people giving, the boom condition, the ex post condition, and then a lot of people split it, right? Splitting it in half at $10, and then actually splitting it somewhere else in the middle. One more thing is that we have a slight concern, because we have all sorts of demographic information when we ask people about, age and income and experience with the patent system and science degree and gender, but we had a little concern anyway that our example was a little gendered because it was a car battery, so we ran actually the same experiment using a different technology. It was a car seat, and the results looked just like this. But then we also were thinking about these splitters, and so we ran the experiment again, and we just kind of forced people. Okay, you have to pick, either the boom or the bust. And so the results are pretty much the same, right? We just kind of force those splitters into one or the other. And again, we have kind of like the modal observation in the bust is that people give the ex post, and the modal observation in the boom is they give the ex ante. And so we're like kind of thinking about like what's going on. And so I think there's like a few things that we kind of see right away, which at least from this experiment, is that we don't really see support for this like Oberg Ben Shahar's argument that people's intuition is to just give the patent owner the higher number. It actually looks like people's intuition is to give them the lower of the number, the lower of the damage amount. With respect to the hindsight bias, that people are just always going to gravitate to ex post, we also don't see that, right? It seems like people are, you know, at least when we force people, it's a relatively high majority that pick the lower number in both situations. Now, when we combine, you know, these results from the kind of boom and bust, you know, the overall number ends up being, you know, kind of undercompensation to the plaintiff, right? So if we're looking at like kind of the lottery ticket example, the total money that changes hands is less than $100. And so we're you know kind of thinking through this like splitting issue. Like we've artificially forced people to pick, and then we had people give like a narrative. You know, after they had answered everything at the end of the demographics, like why did you come up with, you know, your number? And so there were two things in there that were kind of interesting. The first is that there were some people that just thought that because it was independent invention, that there should, you know, that should be they should either give no money or give like a lot lower money, even though we didn't talk about, you know, we didn't instruct them on intent or anything like that. We could think of patents as being a strict liability tort. That was something that was in people's minds, and when we coded those comments that people made, people that mentioned anything about intent, you know, gave us a significantly lower damage award than people who did not. About 25% of the respondents mentioned intent. The second is that there were a small number, but not an insignificant number, maybe 5 to 10% of people that just said, I think patents are bad, I think the system doesn't make any sense, and I think you should give $0, right, or give the minimum when we force them. And so that was something that was in the data. And so just kind of, again, we don't find any support for either the kind of hypotheses about overcompensation with greater of or hindsight bias. Now, to be fair, you know, we didn't tell people what to do. This is just their intuition. So we might think that jury instructions tell jurors how to calculate things. And this like evidence of good faith by independent invention is important, or at least was important to 25% of the people. And so I want to talk for a few minutes about next steps. And so what we're thinking about is that we've set up a problem where the probabilities are, the invention is kind of a long shot. Yeah, I mean, that's what the probability is, like if you work it out from saying that the bust is 5 and the boom is 15, but the ex ante is only 5. And so so we could, you know, fiddle with those and change it so that it's more of like a 50-50 or an 80-20 or a 20-80. And so that's kind of where we're thinking would be like the most fruitful next direction, just to see if the same kind of distribution occurs when we run the experiment. The way that, you know, we could do it is you could either set the ex ante or you could set the ex post and then use this kind of formula to figure out the other one. And we think it's probably, although I'm interested if anyone has feedback on this, useful to set the ex ante value. Just set it at like $10 or something like that, and then work out what the other amounts would be from there, and see, and then, you know, run this experiment. And then, you know, the other kind of related experiments. So we've actually run some on state of mind and didn't find anything particularly insightful or interesting. One could change the industries, right? So we picked a rather neutral mechanical invention, but I suspect that people's intuitions and preferences are different on pharmaceuticals or software. And then we could also change the patent holder. So here we've just kind of picked, to keep it simple, just like individuals and names of 2 individuals. But we could change it to companies, we could change it to big companies, we could change it to kind non-practicing entities, and each one of those might yield different results. And so with that, I welcome comments, questions. Yep.
When you're talking about variations, one thing I'd like to see you try and vary too is whether they agree ex ante that essentially you have about the most sympathetic infringer possible in that they essentially cop to infringement, whereas your normal setup before a jury is going to be that you have an infringer who fought all the way in front of the same jury and then says, okay, you found me infringing and now you should award me the lowest possible damages, and the jury might not take nearly so kindly to that as if they cop right up, well, we infringed, sorry, we're just fighting over.
Although that is the same in both, to both people to get the truth and the control.
Right, but
we can change it for both.
You got the same result that they were pro defendant in both instances, and I'm wondering whether that sympathy is a factor that explains partially that result. The second is, could you bring up the final call again?
This one?
No, the call. The call of the question.
This one,
yeah. Is that a typo? Because the second one, S1 per unit, the amount the patent was worth when Fred initially violated the law.
that
Should
might
be.
be.
They're two different.
Yeah,
No,
you know what, this is copied here, but you're right. I typed this here, but we
Okay,
didn't
so
write it.
that's not the
That's the ex post value, it's not the initially.
Okay, but that's not
right.
the one you presented to
That
me.
is correct. I mean, we'll check that, but
Yeah.
that's not. Very, very cool. Mark.
So one of the things that was interesting to me is, I mean, if you in the bust numbers, right, you get 1 and 5, but that's what the plaintiff and the defendant are asking for, right? In the boom numbers, they're asking for 5 and 15, and that's the only instance in which what the plaintiff or defendant are asking for differs from the ex ante or ex post number.
Say
right?
that again, the 5 and 15, that is the ex ante and ex post.
No, the ex ante was 1, as I understood it, right? It was a
The activity's 5 in both.
okay.
in
All right,
both
fair
cases.
enough. So what I wonder is whether what's going on here is actually driven by the fact that you give them, here's what the plaintiff wants, here's what the defendant wants, right? Which you may well be observing is not anything about ex ante or ex post at all, right? It's yeah, right. So I am a juror, right? I might think, I should either pick what the plaintiff wants or pick what the defendant wants, or some number of jurors will say, well, I'm in the middle, so I'll split the two, right? And so if you ran the same test and just you gave them the factual background and then said, how much should they award, and didn't say, here's how much plaintiff is asking for, how much is defendant is asking for, it would be interesting to see if the results change.
Okay. Okay.
Because I mean, I just think they may well be anchoring on, well, if maybe we'd give the plaintiff $20, but they're not asking for it, or maybe we want to award nothing, but we wouldn't if the defendant says defendant's willing to pay $5, we're certainly not going to give them less than that. And a few people would.
Okay, fair enough. Paul.
Yeah, you mentioned jury instructions. All of this research is going to have way more salience if jury instructions don't change the results. Right.
Right. I mean, so right now,
So,
clearly, we're just looking at people's intuitions, and we have not.
But I'd love to, and you mentioned already, but I'd love to know, because if jury instructions change results to get what we want, then we don't need to worry.
So I have a question about why you're asking this particular question. What I understand we're getting a psychological response about what people understand to be fair, right?
Right.
But how is that relevant to the IP law, right? Because law right now says you either get this or this if you can prove it, but we don't, in theory, give the jury that discretion to choose between one or the other. So I'm trying to figure out how this assessment of fairness kind of is something other than probe into the, the mind of the average person as to whether patent law is fair, which is a question that we often have reticence to ask.
Yeah, okay. I mean, so I see that as like similar to Paul's question, right, which is, we should just care about what the jury instructions do. Why do we care what people's intuitions are? And I think that, and I let Chris chime in too if he wants, but then I think that, how jury instructions operate is actually affected by what your priors are going into that, and so it's useful to know like what people's intuitions are, especially with respect to hindsight, or whether people think that we should overcompensate. But it's clear that you're right, jury instructions could correct this, and maybe we should be more interested in the post-jury instruction issue, although if we wanted to move this outside of just the litigation context, maybe we're not interested only in jury instructions.
So I have a suggestion for the next step.
Yeah.
I guess so I have a hypothesis, which is that if you somehow manage to do this study on real jurors, you'd find, in real situations, you'd find exactly the opposite result. You seem to think, part of your story about why they're picking the lower number in both cases is that some people are just generally anti-patent, or maybe some people don't think that this particular patentee deserves to recover because there's an invention. If you're asking actual jurors, if they've just decided liability in the case, they presumably just decided that the patent is good, and maybe patents in general are good, and this person deserves to recover. And so, whereas these people look like they were biased down, your real jurors who've just decided that for liability might be biased up. So my suggestion for a different way of running the study is, why don't you ask them a liability question first, and then you'll get answers as to whether these people think there ought to be liability or not. And then you ask them the damages question, and you could look to see whether people who vote for liability in the first instance bias their damages up, and people who vote against liability in the first instance bias their damages down.
That's cute. I mean, so our hypothesis has to do a little bit more with like this is like a lottery ticket, and people don't like lottery ticket stuff, but that's a different theory.
But your data seem to contradict that a little bit, because sometimes they like the ex ante number, and sometimes they like the ex post number.
Okay.
So it might be, as you say, it might be something else.
Useful. All right.
Just kind of about the splitters. I wonder if, is infringement ongoing through 2014? When does infringement stop?
So we didn't really specify that.
So I was thinking I would split if I'm thinking, okay, the expected value is 5 in 2010, but if infringement's ongoing, by 2014, they knew the value was 15, and so it would be more fair to have, a rate that's rising. What if that explains some of the splitting? I'm not sure how to address that.
Okay. Yeah, that's useful. All right. Thanks, guys.